Namaste. Today I would like to share some information with regard to the Karnataka Land Reforms Act 1961. Prior to the advent of Karnataka Land Reforms 1961 Act, in Karnataka state there were 5 enactments. One is the Bombay Tenancy and Agricultural Lands Act 1948 as in force in Bombay area, that is northern part of the Karnataka. 2. The Hyderabad Tenancy and Agricultural Lands Act 1950 as in force in Hyderabad area. 3. The Mysore Tenancy Act 1952 as in force in the Mysore area including Bellary district. 4. The Madras Cultivating Tenants Protection Act 1955 and Madras Cultivating Tenants Payment of Fair Rent Act 1956 as in force in South Canara and Kollegal Taluk. 5. The Court Tenants Act 1957 as in force in the Kuru district. Therefore, the legislature thought it fit to have a consolidated act throughout the state of Karnataka, and accordingly the Karnataka Land Reforms Act 1961 was enacted, and which came into force in the whole state of Karnataka on 5th March of 1962. The Land Reforms Act has suffered several amendments, more than 40 amendments so far, out of which some amendments have much significance, but some amendments, of course, they are necessitated due to the change of time. As per the amended provisions, the landlord was provided to file rent recovery cases and also resumption of land cases against the tenants. But the major surgery was made to the Karnataka Land Reforms Act in 1974, in which some sections are incorporated in the main act, and mainly section 44, in which the section 44 of the Karnataka Land Reforms Act says that all tenanted lands shall vest with the state government free from all encumbrances, notwithstanding any decree or order passed by any court. That is why I told you earlier that some amendments have provided the landlords to file resumption of land cases, RLC cases, as well as rent recovery cases. But if any decree is secured by the landlord without having any effect, all the lands were vested in the state as on 1/3/1974 as per section 44 of the Karnataka Land Reforms Act. Then under section 48A of the Karnataka Land Reforms Act, every tenant, either permanent or protected or deemed tenant, or every tenant is permitted to file declaration in form number 7 before the land tribunal. The land tribunal was constituted under section 48, in which assistant commissioner is the chairman and 4 members will be the persons appointed by the state, and every application will be inquired by the land tribunal by issuing notice to both parties. After both parties have appeared before the land tribunal, opportunity shall be given to the parties to submit their statements, to record evidence, to produce documents, and if necessary, the land tribunal can hold spot inspection, and after arguments, the land tribunal will render judgment. It is clearly mentioned that under Rule 17 of the Karnataka Land Reforms Act, that what is the procedure to be followed while holding due inquiry. If procedure is not followed, then that vitiates the entire proceedings, and in many cases the Honorable High Court has remanded for non-compliance of the Rule 17 of the Karnataka Land Reforms rules, and matters were remitted to the land tribunal for holding fresh inquiry. Then in the land tribunal, after holding inquiry, grants occupancy right, and if nobody prefers any writ before the Honorable High Court, then it becomes final, and under section 55 of the Karnataka Land Reforms Act, concerned Tahsildar will grant occupancy certificate to the tenant. Then that is why the leasehold right becomes freehold right. Till then applicant was a tenant, and only after grant of occupancy right he will become an occupant and he will become the owner of the land. And some restrictions are imposed while granting the property by the land tribunal. One restriction is that under section 61, that if any property is granted by the land tribunal, it shall not be alienated for a period of 15 years. That is a bar for sale or exchange or gift, whatever be the transfer shall not be made. This provision is incorporated to ensure that the property must be with the agriculturists only. It shall not be alienated, it shall not be wasted. But after the expiry of 15 years, the property could be sold, and in most of the cases nowadays that period of prohibition is expired and properties were already sold. And under section 61 of the Karnataka Land Reforms Act, even a provision was given that the land can be mortgaged in favor of scheduled banks, nationalized banks, cooperative societies, and loan can be availed for the development of the properties, but it shall not be alienated. And the question arose that whether will can be executed in respect of a property granted by the land tribunal, whether section 61 bar is there. In the Honorable High Court and Supreme Court has held that will can be executed by the occupant, provided that it shall be executed only to his heir and not to third parties, because a tenant or the occupant till the expiry of 15 years, he cannot transfer the property to stranger. What he cannot do during his lifetime cannot be done after his lifetime. That is why under that policy he was not permitted to bequeath the property in favor of strangers. The main three ingredients that are to be satisfied to grant occupancy right in favor of a tenant is that the property must be agricultural land. Second ingredient is that the applicant must be a tenant as on 1/3/1974 and prior to it. Third is that he must be in possession, in cultivation, personal cultivation of the property. If these three ingredients are satisfied, then the land tribunal grants occupancy right in favor of the applicant. Otherwise, his application will be rejected. There are many authorities. The Honorable High Court has held that what is that agricultural property? In simple definition, I can say that, of course, definition is given under the Karnataka Land Reforms Act, but we can say that house site is not an agricultural land. Or if a land is used for non-agricultural purposes, it is not an agricultural land. But for all other purposes, horticulture, sericulture, these properties, the gardening, then the property is an agricultural land. Then the question arose before the Honorable High Court that whether punja land or dry land is an agricultural land or not. Then the Honorable High Court has held that punja land is not an agricultural land unless and until it is brought under cultivation. If it is shown to the land tribunal that as on 1/3/1974 and prior to it, the property was brought under cultivation, then punja land is also an agricultural land. Particularly in South Kerala district, if some coconut trees are there in the land, then it cannot be said that in a punja land is an agricultural land. That is why the Honorable High Court has held that punja land, just for the reason that declaration is submitted, it cannot be said that he is eligible for grant of that land unless the cultivation of the land as on 1/3/1974 and prior to it is proved. The land tribunal is vested with the powers such as issue of injunction, appointment of receiver also, to pass any orders under section 48C of the Karnataka Land Reforms Act. Initially it was not there. Later it was amended by way of amendment, and this section was incorporated. Similarly, if there is any clerical mistake in the land tribunal order under section 48A6, applicant is permitted to submit application for correction of order of land tribunal, and land tribunal order can be corrected. In the initial stage, there was no appellate authority against the order passed by the land tribunal. The order passed by the land tribunal was final. In 1986, an appellate authority was created to challenge the order passed by the land tribunal, and it was felt that it is not functioning proper, and therefore in 1990 that appellate authority was abolished, and again the order of the land tribunal had become final, made it become final, and only any person, if aggrieved by the order of the land tribunal, he is permitted to challenge the same before the Honorable High Court of Karnataka under Article 226 and 227 of the Constitution of India. This is the only remedy now which is available to all the parties, to the litigants, to the tribunal proceedings before the land tribunal. And even till today, there are many matters which went up to High Court and they are remanded back to the land tribunal, and many matters are still pending before the land tribunal for inquiry. After the abolition of appellate authority, some time was given to every person to file application to convert the appeal into writ petition, to file civil petition before the Honorable High Court, and probably 3 months time was given, and within which any person who is the appellant before the appellate court, appellate tribunal, was permitted to file civil petition before the Honorable High Court of Karnataka, and the civil petition was converted into writ petition, and again writ petitions were disposed and matters were remitted to the land tribunal. Or in some matters, Honorable High Court itself has decided the matters. In some matters, no civil petition was filed by the parties and the appeal ended therein itself. This is the progress of the matters in the land tribunal. Another important provision in the Land Reforms Act is that Section 63, that sealing on land was incorporated. That sealing area for a person who is not a member of a family or who has no family or a family shall be 10 units. Then if a person is having family consisting of 5 members, then sealing limit shall be 10 units plus 2 units. Then see the sealing area of a member with more than 5 members, with family members, then the sealing limit is 20 units. And this units, 1 unit is equal to, approximately I am telling, dry land is 4.5 acres of land. Then it is to be multiplied. Then single individual can hold the dry land up to the extent of 45 acres. Similarly, we can calculate the same. And if any person is having more than the ceiling limit, he was supposed to submit declaration before the Tahsildar that I am holding this much surplus land. Then the Tahsildar shall take the custody or the possession of the excess land, and the excess land so available shall be, that is the surplus land, that shall be divided to the, that shall be allotted to the landless persons under Section 77A of the Karnataka Land Reforms Act. If anybody withholds any information as far as the surplus land is concerned, that is an offence and penalty could be imposed under Section 125 of the Karnataka Land Reforms Act. And also under Section 66A of the Karnataka Land Reforms Act. Another important amendment was inserted to the Karnataka Land Reforms Act in 1998, where under Section 77A was incorporated, and some of the tenants who could not file Form number 7 in 1974 were permitted again to file Form number 7A declaration, provided that the land shall be cultivated by him as a tenant as on 1/3/1974 and prior to it. That land must be an agricultural land, it must be a tenanted land, and he shall not possess any land more than 1 unit. And in such an event, he was permitted to submit declaration, but that declaration was inquired by the Deputy Commissioner and not by the Land Tribunal as in the earlier 1/3/1974 proceedings. There are sections 79A, 79B, 79C, Section 80, 83 of the Karnataka Land Reforms Act. 79A mainly deals with that if any person who has income other than agriculture, if it exceeds, initially it was 12,000 rupees. If it is more than 12,000 rupees, he was not eligible to purchase agricultural land. Later, it was enhanced to 50,000, and further it was enhanced to again 2 lakhs, and thereafter it was 25 lakhs. Now, by way of recent amendment, there is no such limitation at all. Anybody can purchase. If a person is having any income, any limit other than agricultural sources, he can purchase the agricultural land. Similarly, 79B was there that non-agriculturists could not purchase the property, but that is now removed by way of amendment, and any non-agriculturist can also purchase the agricultural land. This difficulty was removed so that now anybody can purchase the agricultural lands. And the section 83 was incorporated in the Karnataka Land Reforms Act, that if any act is done in violation of the rules and regulations of any transactions are made in violation of the Karnataka Land Reforms Act, then that inquiry with regard to the validity of the document shall be inquired into by the Assistant Commissioner under section 83 of the Karnataka Land Reforms Act. And therefore, number of matters were pending before the concerned authority, and by way of repeal of 79A and 79B, those all matters are ended, and now even non-agriculturists can purchase the property. It is worth to mention section 108 of the Karnataka Land Reforms Act also, because as on 1/3/1974, it is very important to see that whether the property was in the custody of court receiver. Then, if the court receiver, the difference may kindly be noted. If the court receiver executed lease deed in favor of tenants, then such tenant is not entitled for the grant of land. If the land was leased out to a tenant prior to the appointment of court receiver, then as on 1/3/1974 the tenant was there, then definitely he can claim occupancy right under section 108. Is not a bar to claim the occupancy right. And other sections, that is 132 and 133 of the Karnataka Land Reforms Act, are also worth mentioning, because 132 says that any matter touching to any provisions of the Karnataka Land Reforms Act, such disputes cannot be decided by the civil court. It is only the tribunal has got jurisdiction. And 133 says that if any question arises before the court with regard to the tenancy right or the nature of the property, that has to be referred to the land tribunal, and the civil court only after receiving answer from the land tribunal can proceed further with the suit or proceedings before it. Under section 5 of the Karnataka Land Reforms Act, even creation of any lease subsequent to the commencement of the Karnataka Land Reforms Amendment Act 1974 is prohibited. That is, since 1/3/1974, no lease can be created in respect of agricultural land. It is also under section 21, it is stated that subdivision, subletting and assignment are prohibited, because no tenant is permitted to sublet the properties, and the assignment cannot be made, because the tiller must be the owner. That is the main purpose. He cannot alienate the same. He cannot assign the land subsequent to 1/3/1974. And even partition is permissible, but the partition shall not be less than a fragment, because a property shall not be divided into small pieces. Fragmentation, it is Prevention of Fragmentation Act 1969. Later it was repealed in 1991. And at that time, if the property is divided into several small fragments, then it cannot be cultivated. That is why it was that was prohibited under section 21 of the Karnataka Land Reforms Act. As I already told, particular to the South Kannada district, the Madras Cultivating Tenants Protection Act 1955 was in force. Under the said act, tenancy was created in triplicate, by executing Chalageni chits in triplicate. That one copy must be with the tenant, and another copy must be with the landlord, and third copy must be sent to the Tahsildar. In such a way, year-to-year tenancy was created under the 1955 Act. After the grant of occupancy right to a tenant, then the premium that is to be paid must be fixed by the Tahsildar, and the tenant shall pay the premium amount, and that premium amount or the compensation amount will be paid to the landlord either in lump sum or in installments. And whenever a tenant was not able to pay the amount, the land development banks, they used to mortgage the property, and the banks used to pay the compensation amount to the landlord. In 1974, no provision was made to submit declaration by agricultural laborer. In 1974, only some provision was made under section 48A to submit declaration in form number 7 by agricultural tenant. Subsequently, by way of amendment, even to an agricultural laborer, provision was made to submit declaration in form number 2A, and after grant of occupancy right, form number 2C was issued to him, to an agricultural laborer. As far as other conditions are concerned, for agricultural tenant as well as agricultural laborer are one and the same. This video is mainly recorded for the use of law students. I hope that law students make use of it, and thank you for watching the video till the end.